This is NHTV2, North Haven Government Television, a service of North Haven Community Television. The following program is brought to you in part through a grant from the town of North Haven.
Good evening, everyone. My name is Stacy Yarborough. I'm the North Haven Town Clerk. And at this time, pursuant to North Haven's Town Charter, Section 903, I will call this special town meeting to order. As Town Clerk, it's my duty to open the meeting. And also, before we can move forward, I'm in charge of the procedure of all of us electing a moderator. The moderator is nominated and elected by the members of this meeting. It is the moderator's function to bring before the meeting all items of the warning and to assist in obtaining the objective of the meeting, while ensuring the rights of individual voters who wish to be heard. The moderator's duties also include helping any member of the meeting who seeks clarification or to advise them with regard to parliamentary procedure. Further, the moderator must be a registered voter of the town. With that in mind, with regard to any issue voted upon tonight, every person who votes, including the moderator, must be an elector. To be an elector of the town, one must have been a registered voter in our town at the time of the most recent election, or one who pays to the town on an assessment of property of not less than $1,000 on the most recent grand list, a citizen of the United States and 18 years of age or older. This regulation will be in force in effect all night for any vote taken. If you're unsure if you're eligible to vote, please check with me at any time. I do have the list of all registered voters for our town. Now, the floor is open for nominations for our meeting moderator. There's been a nomination for Mr. John Lambert. Is there a second? Any other nominations, please? Okay. All in favor of Mr. John Lambert as the special town meeting moderator, please signify by saying aye. All opposed, say nay. Okay. I now declare Mr. John Lambert as the meeting moderator.
Good evening. The clerk will now read the call of the meeting. Excuse me, the warning and the call of the meeting. Thank you.
The legal voters and those duly qualified to vote in a town meeting of the town of North Haven were warned of the special town meeting to be held tonight by way of a publication in my office and a publication in a local town newspaper. Therefore, having received appropriate written notice and warning of the town as aforementioned, I hereby convene the special town meeting of the electors and citizens qualified to vote at town meetings for the purpose of acting upon and discussing the following two items. Number one, to consider and vote upon whether to adopt amendments to the Soldiers Memorial Ordinance at Chapter 67 of the Ordinances of the Town of North Haven to amend Section 67-1 to formally assume responsibility for the maintenance and preservation of all the memorials and monuments on the town green, and add Section 67-2 to establish certain eligibility criteria for future memorials and monuments. And number two, to consider and vote upon whether to adopt an amendment to the taxation ordinance at Chapter 184 of the town's ordinances to add Article 10 establishing an ordinance concerning property tax freeze relief for certain elderly homeowners to improve the quality of life of the town's eligible senior residents and encourage their continued residence and property ownership. A copy of the proposed amendments to Chapter 67 and Chapter 184 of the ordinances of the town of North Haven have been on file and available for inspection in my office.
Please be advised that because this is a special town meeting, no other business will be conducted during the course of tonight's meeting. I'll ask the town clerk to now read the first resolution That is the first item on the agenda.
Resolved, number one, resolved, that in accordance with the recommendation of the Board of Selectmen, amendments to the Soldiers Memorial Ordinance at Chapter 67 of the ordinances of the Town of North Haven are hereby approved and adopted to amend Section 67-1 to formally assume responsibility for the maintenance and preservation of all the memorials and monuments on the town green, and add Section 67-2 to establish certain eligibility criteria for future memorials and monuments. The amended Chapter 67 shall be published in a newspaper having a circulation in the town of North Haven and shall be effective 15 days after publication. Is there a second? Thank you.
I call for discussion. Let me recognize the town attorney, Jennifer Capola, and would ask that other people coming before who have not been identified, identify yourself and give your address for the town meeting.
Good evening, everybody. My name again is Jennifer Capola. I work at Sewell and D'Onofrio on Washington Avenue. We are outside counsel for the town. I'm going to be presenting to you tonight both ordinances that are up for consideration. The first one, as indicated by the clerk, is an amendment to the Soldiers Memorial. There is an amendment to Section 67-1, which was an existing section, which calls for the preservation, or the town assuming all responsibility for the preservation of all soldiers, veterans, or war memorials or monuments on the town green. Originally, that section read, and currently reads, as you have not yet adopted the revised language, that the town is assuming responsibility only for the Soldiers Memorial. So this will cover all memorials, again, and monuments on the green. We are also proposing to add tonight Section 67-2, which will determine eligibility criteria for future memorials or monuments. I don't know how many of you were actually here at the last town meeting, special town meeting in October of last year when this was proposed. So I am going to take you through this section so that you have an understanding, if you've actually not reviewed the ordinance, the proposed ordinance that is on file in the town clerk's office. It reads as follows, and I will paraphrase certain parts of it because it is quite long. The town of North Haven, ever desirous of honoring those residents of the town who have served honorably for the United States of America in wars and armed conflicts, establishes the following mandatory criteria for an individual to be listed on any future town, soldiers, veterans, or war memorial or monument. Subsection A, the individual must have served at least 90 days on active duty and possess an honorable discharge or still be on active service. An exception to this 90-day requirement will be made if the individual is or was killed or wounded in action, or the duration of the hostile action or conflict in which the individual served was less than 90 days. So that's the first eligibility requirement. The second, subsection B, the individual's Veterans Federal Form DD-214, which is the report of separation, or in some cases his or her long form discharge, must list North Haven, Connecticut as the individual's home of record at the time of his or her service entry. If an individual serves longer than 2 years, whether by reenlistment and or extension of service or reserve obligation, and changes their home of record to North Haven, Connecticut while on active duty, then such individual shall be considered to have North Haven, Connecticut as his or her home of record at the time of his or her service entry. So that's the home of record requirement. Subsection C, all future soldiers, veterans, or war memorials or monuments shall include a special designation for individuals who have the appropriate campaign medal listed on his or her Form DD-214 for the war or conflict claim. The special designation shall appear immediately after the individual's name on the memorial or monument. Again, I answered a question prior to the start of tonight's meeting as to whether or not a specific special designation is being designated in the ordinance. It is not. It's just that that's something that will, I assume, be decided at some further point in time. It's just that it allows this special designation again for somebody who has received one of the campaign medals that is listed. And there are a number of campaign medals listed. I'm not going to go through all of them. There are 15 in number. They start with the World War II Victory Medal and go through the Global War on Terrorism Expeditionary Medal for various engagements throughout the world that began with September 11th. And that's a medal that is still open and eligible for awarding. Another change that we've made since October, so that was a change since when it was originally proposed in October. It was, the original proposal was that if you didn't have the appropriate campaign medal listed, then you could not be eligible for inclusion on the memorial or monument. We did make that change based on comments received from participants at the town meeting that they wanted to be able to include people who served for other reasons, for pacification and humanitarian purposes. So there's some new language that continues after the listing of the campaign medals. I'm going to go through that now. The above list of appropriate campaign medals specifically excludes from eligibility for the special designation on memorial or monument individuals who receive campaigner service awards conveyed for occupation, pacification, or humanitarian purposes, regardless of whether or not a limited hostile fire is or was encountered. Nonetheless, in the event such occupation, pacification, or humanitarian purposes result in an individual being killed, awarded a Purple Heart, combat infantry badge, or combat action ribbon, then such individual shall be considered to be eligible for the special designation to be included on a memorial or monument. So again, individuals who have served for occupation, pacification, or humanitarian purposes, they are not going to be excluded from listing. They are going to be included, but they just will not have the special designation of having received a campaign medal. Subsection D, the individual or his or her representative must make a claim to entitlement to be listed on the memorial or monument before the memorial or monument is completed and the final list of veterans to be included is compiled. This language has stayed the same. It's important that the claim be made so that way the monument doesn't have to be altered in any way. It is very, many of these, and Mr. Fowler may come up and talk a little bit to you tonight about his work on this. These memorials are very expensive, so that's an important requirement. However, if an individual is known to the town, this is an exception, if the individual is known to the town to meet the 3 preceding requirements and does not make a claim to be listed or was killed in action, the town can add that individual's name to the memorial or monument with consent of the individual or his or her next of kin at the time that the final list of veterans to be included is compiled. And then finally, subsection E just indicates that there's not going to be any exceptions to the requirements provided in subsections A through D, and the burden of meeting these requirements rests solely on the individual veteran seeking to be included and the memorial or monument or his or her next of kin or appointed representative. And that is the proposal before you tonight. Thank you.
Thank you. Anyone else? Yes, please come forward, state your name and address.
Good evening, Dave Yench, 61 Blakesley Avenue, lifelong resident of North Haven, which probably puts me up there. Did I understand it to be that the special designation is only going to be on future monuments? Just future monuments, not the existing ones. So basically, everyone, Vietnam, Korea, World War II, they will never have a special designation, right? I went in the Marine Corps in February 1966, and less than 4 months later, I found myself in Vietnam. And I spent almost a year and a half in the jungles and mountains in combat was awarded 2 Purple Hearts. And somebody can correct me if I'm wrong, but I believe only 1 in 6 guys that actually were in Vietnam actually saw combat. The other 5, equally important, just as important: transportation, supply, medical, everything else, equally important. So I don't feel that I would need a special designation. Everyone either enlisted or went when called and did what was asked of them. So I really don't think there's a need for a special designation as far as I'm concerned. But if that's what people want to do, you've basically eliminated everyone from Vietnam back. But that's all right with me. I don't mind that. And just one other comment about the memorials that are there. I go to the concerts on the green, and every time there's kids jumping all over them, into the shrubbery around them, just constant. It never stops. Parents are there. The police are walking around. Nobody ever says anything to them. I just think it's disrespectful. I think maybe somebody should, I don't know, tell the cops that are there if they see the kids to stop it, or put a sign there or something, but just my own comment. All right, thank you.
Mr. Salmon.
Thank you. Roger with a D and Salmon with 2 A's, and I live on Drazen Drive. I take exception to the eligibility for criteria for future memorials or monuments.
Why don't you use your mic if we can't hear you? Raise your mic into it. I'm sorry.
Thank you.
Sorry.
You're excused. Section B, the Individual Veterans Federal Form DD 214 requires you to be a resident of North Haven. Now, I've lived in this town 35 years, but I spent my time in the military before I moved to North Haven. So this precludes me from any special exemptions. So that's all I want to say.
Yes. Please come forward.
Mary White, Summer Lane. I'd like to begin as I did last year when I spoke. I want to thank all the soldiers and all veterans for their service and sacrifice. For without them, we would not be able to enjoy the freedoms we have today. Last year, I stated I was in favor of a soldiers' memorial, but I could not be in favor of the war memorial that was being proposed because of the exclusionary language. Since then, changes have been made, and all deserving North Haven soldiers and veterans will be included, and there will be a special designation of a sword for those who served in combat assignments. The original proposal was for only soldiers from North Haven who had served in combat assignments. So this proposal now represents a compromise, and I am very pleased of these changes. I was not in favor of the exclusionary language. It really bothered me. So again, I just want to say that I'm still in favor of a soldiers' memorial, and I am in favor of this one because the people who were excluded, the deserving soldiers who were excluded, are now going to be included. So I would be in support of this proposal, and I encourage others to support it as well.
Thank you. Is there anyone else? Yes.
Honorable First Selectman, ladies and gentlemen. My name is Dan Ricchio. I'm commander of Post 76 for 13 years. Been in the post for almost 40. I reside at 195 Menomet Avenue, North Haven. I've been asked by my fellow veterans to speak to you this evening in regards to this monument. I was approached 2.5 years ago by our Honorable First Selectman to speak in regards to putting a monument next to the monuments that we presently have on our green today. And we were all for it. There were 7 original members, including myself, Mr. Frieda, Mr. Yacarino, our state rep, Charlie Morrissey, my predecessor and former state commander, who's been involved with this as well. We've been speaking to everyone in the state. Also Mr. Alan Fredrickson and our former retired Colonel Marines, Mr. Fowler. We asked Mr. Fowler to put something together for us, and he did a wonderful job putting an ordinance together, which we all approved. At that time, we decided we wanted to go ahead and move forward with this. Unfortunately, at that last meeting, I was ill and I couldn't attend, and then I left Mr. Fowler all by himself without any information, and I apologize for that, sir. But I want you to know that we are for the monument. However, I'm getting many calls. They do not want a designated sword because there's a lot of guys that served in Guadalcanal, Iwo Jima, Pacific, and also in the Battle of the Bulge that do not have a sword next to their name. And to me, these are real heroes. I was only an NCO, non-commissioned officer. I only had 2 years of college at the time. I was drafted out of college in '68. But I did my 6 years, and I'm proud to have served. And I'm proud for all you gentlemen and ladies here that have served. I just ask that we do move forward with the monument. However, I would ask that we delineate and take away the sword, because I'm already getting calls from World War II, Korea, Vietnam, saying, am I gonna get a sword? I served in combat. There were a lot of guys that were in a combat zone that never got action or saw action. Now, my brother was in action. He was in the 1st Cavalry. He's got 2 Purple Hearts. His name isn't even on the wall here in North Haven. But unfortunately, we can't do anything about that now. I'm still getting calls from aunts, relatives, and children from World War II saying, my dad's not on there. I mean, there's nothing I can do. I've tried. Mr. Frieda has tried. He's the first selectman I've worked with that went out of his way to try to do anything to really push this forward. And I feel for these guys that are not on there. But it is what it is, and all I can say is I would appreciate if we do not put the sword by the name of the individual. It was intended with Mr. Gorge, who is still living, God bless him, and Mr. Palmieri, to honor the people who served from the town and their country at the time of war. That's all it was. You had to serve 90 days of active duty in time of war, and you had to be from this town. Unfortunately, I've seen some of the names on the plaques. Some of them are in East Haven, Hampton, and North Haven. I know one guy that's on 3 of them. Unfortunately, he moved here, paid his taxes here. They saw that he paid his taxes here. He's getting a tax break on the house, put him on the wall. It's not the way it was meant to be. Unfortunately, it happened, and it's done. Nothing I can do to correct it. But I will try to say that I do feel we should not put the sword next to the name. That's the end of, as far as the parade, sir. I've been doing the parade, Memorial Day parade, 18 years, and I will make sure that we try to clean up that information and get it out to the right people. I will meet with the police department next week about something else, and I'll mention that incident with what you spoke about. And thank you for your service. Thank you.
Yes, Mr. Fowler.
Ray Fowler, 6 Todd Drive, retired Marine. This has been a very emotional issue for a lot of people. A compromise was reached, and it was a good one. Now, every veteran who served during time of war with an honorable discharge who lives in North Haven will be listed on the memorial, regardless of whether they had any combat or in-country service. That's done, that's fine. There's also a sizable number of the veteran population that wanted some kind of an in-country or combat designator next to the name of people who actually were there. We made that compromise. So this is a deal where it's a win-win. Everybody should walk away happy. Now, I'd like to address a couple of the other things that have been mentioned. Sir, in terms of your not being on the North Haven Memorial, while you may not qualify for North Haven, I would urge you to go back to wherever you lived at the time of entry into the service and ask that your name be included on that town's memorial, because you certainly would be qualified to be on that memorial. To go to the question of the combat designator, my fellow Marine, Semper Fi, brother, certainly it would be great if we could go back and take the World War II, the Korea, if that matter, the World War I, which is in Town Hall, World War I, World War II, Korea, Vietnam, if we could go back and put the combat designator next to those names, and by the way, my name's on the Vietnam Memorial, and even though I served 2.5 tours and was highly decorated, there's no combat designator next to my name either. The problem with it is, it would be so incredibly expensive to go back and recast all of those memorials. And that's what you're talking about. You'd have to recast them. And I can tell you, bronze casting is expensive. You know, it really is. And that's why we said all future war memorials, so that in a way, the injustice that was done to all those fine veterans of all past conflicts, myself included, like I say, I'm on the memorial, but so we can redress that wrong, we said all future memorials, the ones that haven't been cast yet, the ones that are going to be paid for anyway, let's put the designator next to their name. So we've kind of righted that wrong, so to speak. It's an excellent compromise. It's a win-win. Everybody gets what they want. Now, to have a slight disagreement with my friend and commander of the American Legion, of which I am a member, why should there be a combat designator? I want to try and explain. And if I get a little emotional here, I hope you'll forgive me. You see, the difference between a combat veteran and a non-combat veteran, let me try and sum it up in a nutshell. Everybody who joins the United States military or who is drafted in the United States military, in my opinion, based on 26 years of service, is a hero. They joined, they did what they were ordered to do, they did what they had to do, and just like you, I say, God bless them all. But you see the difference between a combat veteran and a non-combat veteran? Well, the combat veteran, he sweeps in the mud. He sweeps in a swamp. He sleeps on rocks. And when he wakes up in the morning, the first thing he has to check for is to see if every insect, every leech in the immediate area hasn't decided to use his body as though it were the local McDonald's restaurant. The non-combat veteran doesn't have to do that. The combat veteran can tell you about his buddy, about his friend, who's lying there after being hit by an enemy shell with the guts pouring out of him. He has to look at that kid, by kid I mean 18, 19, sometimes 17 years old. He has to look at that kid, even though he knows this kid's gonna die any second. He has to look at that kid and say, it's all right, you're gonna be all right, you're gonna be all right. And then you watch him die. And you carry the memory of it for the rest of your life. And then there's the case where you have to write a letter home. And normally it's to a parent. And you write the letter home and you say, "Dear Mr. and Mrs. So-and-so, your son died gallantly and died bravely and defended his country." And every once in a while, it only happens in rare instances, the parent will write back. And I'm going to tell you something. You only get two kinds of responses when the parents write back. One response says, "Thank you so very much for what you did for our son." The second response you get back is, "God damn you for what you did to our son." And the non-combat veteran never has to experience that. The non-combat veteran never has to be standing next to somebody in the heat of a battle. And all of a sudden, that person is gone, vaporized, because they stood on a landmine and got blown up. And you look, the only way you know that they were vaporized, because you can't find a body, the only way they know that you know they were vaporized is you look down on your uniform and there's drops of his blood and maybe part of his guts. And you live with that for the rest of your life. Non-combat veterans don't have to do that. And then, if you're lucky and you live and you survive and you make it through and you come home and you get married and you raise a family and you enjoy all the freedoms and protections that somebody's sacrifice made for you, and that you were proud to stand there with them while they did it. And every time you feel like you've done some good in this life, every time you feel like you've helped somebody, there's this lingering question that's always in the back of your mind. If that person who died lived, would they have done something better than I did? Why do I deserve to live while they're dead? And you ask yourself that question all the time. And now somebody wants to argue whether a special designator is needed. Obviously, those are the people who've never been in combat. Ladies and gentlemen, I've been in 4 wars in my lifetime, and I'm here to tell you something right now. May it be God's will and God's grace that we never have another war anywhere. I have a son and I have 2 grandchildren. I hope they never have to experience war. But you know what? The odds are against it. Because I think that every American from the Revolutionary War to today wishes there's never going to be another war, but there always seems to be another one around the corner. This deal that was struck is a good deal. It's an honest deal. It's a fair deal. Please vote in favor of this. And please remember the reasons that I've listed. Because I'm here to tell you now, the things I've described to you, I'm 72 years old. I don't know how much longer I'm going to live, but I'll tell you this. However long I live, I'll never forget them. I ask that the chair call the question.
Thank you, Mr. Fowler. Thank you. Seeing no other hands, I will call for a vote. All in favor of the first resolution, please say aye. All against, say nay. I declare the resolution passed and ask the town clerk to read the second and final resolution of tonight's meeting.
Thank you, Mr. Lambert. Thank you. Number 2, resolve that in accordance with the recommendation of the Board of Selectmen, an amendment to the taxation ordinance at Chapter 184 of the ordinances of the Town of North Haven is hereby approved and adopted to add Article 10 establishing an ordinance concerning property tax freeze relief for certain elderly homeowners to improve the quality of life of the town's eligible senior residents and encourage their continued residence in property ownership. Article 10 of Chapter 184 shall be published in a newspaper having a circulation in the town of North Haven and shall be effective 15 days after publication. Is there a second? Thank you.
I'll call for discussion on the second resolution, reminding everybody here that anyone who speaks will not get a chance until everyone, to speak a second time, until everyone else has spoken. And I look to the town attorney who wishes to be recognized, and so I recognize her.
Okay, apologize. I definitely need the microphone, as the people who know me know. Okay, I'm going to take you through the proposed senior tax freeze program, the ordinance. It's Article 10. It's going to be an amendment to the taxation ordinance at Chapter 184, so it's an additional article. The title: the article shall be known, and this is 184-38. This article shall be known and may be cited as the ordinance concerning property tax freeze relief for certain elderly homeowners. The legislative authority, the next section, 184-39. The article is being enacted pursuant to the provisions of Connecticut General Statute Section 12-170V and 12-170W. 184-40, findings and purpose. This is important when considering the content of the ordinance. The town of North Haven finds that it is fair and equitable and in the best interest of the town of North Haven to provide property tax freeze relief to certain eligible elderly homeowners as permitted by state law. Again, as I've stated, that state law is 12-170V and 12-170W. Accordingly, pursuant to the authority granted to municipalities by Connecticut General Statute Section 12-170V and Section 12-170W, the town of North Haven seeks to improve the quality of life for its senior residents and encourage continued residence and property ownership in the town of North Haven by establishing this ordinance. 184-41, eligibility and benefits. Section A, eligible homeowners, effective April 15th, 2016, and applicable to assessment years commencing on or after October 1st, 2015, through the current revaluation period, which ends with the 2019 grand list, and there's a reference there, see section 184-46, because the ordinance does have a sunset provision, and I will reach that at the end. An owner of real property in the town of North Haven or any tenant for life or for a term of years liable for property taxes to the town of North Haven under 12-48 of the Connecticut General Statutes, who meets the qualifications stated in this section shall be entitled to pay, and this is the benefit, The tax levied on such property calculated in accordance with the provisions of Section 184-41, Section B of this article, for the first year the claim for such tax relief is filed and approved in accordance with the provisions of this article. This language is from the statute, 12-170V. Such person shall be entitled to continue to pay the amount of such tax or such lesser amount as may be levied in any year during each subsequent year that such person meets such qualifications, and the surviving spouse of such real property owner or tenant, qualified in accordance with the requirements pertaining to a surviving spouse in this section, or any owner or tenant possessing a joint interest in such real property with the homeowner at the time of the homeowner's death and qualified at such time in accordance with the requirements of the section, shall be entitled to continue to pay the amount of such tax or such lesser amount as may be levied in any year as it becomes due each year following the death of the homeowner, for as long as the surviving spouse or joint owner or joint tenant is qualified in accordance with the requirements. I know it's a lot of language. It's from the statute. Without the statute, we have no authority to pass such a program. Okay, so we have to follow the statutory language. I go on to subsection 2 of Section A of 184-41. To qualify for the tax relief provided in this section, a homeowner shall meet all the following requirements. These requirements are from 12-170V. On December 31st of the calendar year preceding the year in which a claim is filed, he or she must be 70 years of age or over. 2, the spouse of a person 70 years of age or over, provided such spouse is domiciled with such person. Or 3, 62 years of age or over, and the surviving spouse of a taxpayer who at the time of such taxpayer's death had qualified and was entitled to tax relief, provided such surviving spouse was domiciled with such homeowner at the time of the taxpayer's death. Language from the statute. B, again, section 184-41, A, subsection 2B, occupy such real property as his, her, or their, because you could have people filing jointly, principal residence. Subsection 2C, on December 31st of the calendar year preceding the year in which a claim is filed, the homeowner and or his or her spouse shall have resided continuously within the town of North Haven for at least 5 years before filing a claim for relief under this article. D, the taxable and non-taxable income of such taxpayer, the total of which shall hereinafter be called qualifying income in the tax year of such homeowner ending immediately preceding the date of application for benefits under the property tax freeze relief program in this article, was not in excess of limits set forth in Connecticut General Statute Section 12-170AA as adjusted annually, evidence of which income shall be submitted to the assessor of the town of North Haven in such form and manner as the assessor may prescribe. Income limits. Income limits different than asset limits. There have been articles in the newspaper that have talked about both. The income limits are set by the statute, and they require that the income limits that are used by the assessor in determining whether or not somebody qualifies for this program, that he use the income limits of the state circuit breaker program, which is governed by 12-170AA. If anybody has any questions about that, please get up, ask me. We could talk some more about it. It is, though, a requirement of the statute that we're acting under, which is 12-170V, that we follow the income limits for this type of program, which is freezing the amount of tax you pay that the income limits that we follow be those income limits. And the income limits are actually, the assessor receives a letter every year from the Secretary of OPM, the Office of Policy and Management for the state, setting those income limits. And that's what 12-170AA provides. Assets. Okay, we're going to talk about assets now. It's important to keep in mind, if you've read any of the articles, you may understand that the Board of Selectmen and assets was an option under the statute. The town could include an asset limit, they could not include an asset limit or limits, as the statute reads. The Board of Selectmen established an advisory committee to discuss whether or not assets should be included, and certain recommendations were made by that advisory committee to the Board of Selectmen to be included in the proposed ordinance that's being presented to you tonight. The advisory committee did not determine income limits. There's been some misinformation about that. They determined asset limits. They made recommendations on asset limits. They did not make any recommendation as far as income requirements. The statute is very clear. The income requirements that must be included must follow 12-170AA. That is why there was no authority given by the Board of Selectmen to the advisory committee to make any recommendations as far as income limits is concerned. Now I want to talk about asset limits, okay? This is in section 184. I see a lot of you have copies, which really excites me because that means you've read it and you've maybe digested it and maybe you have some good questions. I love feedback, so I'm happy to see people have copies out. Section 184-41, subsection A, and this is 2E. The assets of the taxpayers applying for benefits shall not exceed the following limits. And I know this was set forth in some great articles written by reporters for the local newspapers, but I'm going to take you through it. For taxpayer applicants who have resided continuously in the town of North Haven for 5 to 10 years, an asset limit of $150,000 for single taxpayer applicants and $200,000 for married taxpayer applicants, excluding the principal residence for which property tax relief is being sought up to a fair market value of $500,000. That exclusion applies to the additional asset limits that have been recommended by the advisory committee that the Board of Selectmen okayed to be included in what's proposed tonight. Second asset limit level. For taxpayer applicants who have resided continuously in the town of North Haven for over 10 years to 20 years, an asset limit of $200,000 for single taxpayer applicants and $250,000 for married taxpayer applicants, again, excluding the principal residence for which property tax relief is being sought up to a fair market value of $500,000. And finally, the last level, for taxpayer applicants who have resided continuously in the town of North Haven for over 20 years, an asset limit of $250,000 for single taxpayer applicants and $300,000 for married taxpayer applicants, excluding the principal residence for which property tax relief is being sought, up to a fair market value of $500,000. Taxpayers, this is subsection 2F, taxpayers whose principal residence has a fair market value of over $500,000 as determined by the assessor shall not be permitted to file an application for relief under this article. That was a recommendation that came out of the advisory committee. The Board of Selectmen agreed with it. It's been included in the proposed ordinance. Here's the other piece recommended by the advisory committee, subsection 2G. In determining compliance with the asset limits contained in subsection E above, countable assets shall include all items of value, emphasis added, owned by the taxpayer or taxpayer applicants, including but not limited to, 1, Real property other than the principal residence for which property tax relief is being sought. So if you own another property in North Haven or someplace else, that's counted towards your asset limit. 2, all bank and credit union accounts. 3, certificates of deposit. 4, stocks. 5, bonds. 6, retirement accounts. And there's some definitional language after that item. Investment accounts funded, at least in part by the taxpayer applicant or applicants, which under the control of the taxpayer applicant or applicants, money can be taken out as he or she chooses. 7, annuities. 8, cash on hand. 9, all vehicles. 10, business assets. 11, revocable trust established by the taxpayer applicant or applicants. And 12, trusts for which the taxpayer applicant or applicants is or are the beneficiary or beneficiaries, and from which distribution is available to meet household expenses. What do all of these things have in common? They're liquid assets. So what's not going to be counted towards the applicable asset limit? Assets which shall not be counted towards the applicable asset limit shall be 1, furnishings and fixtures of the principal residence. 2, pensions, and again, some defining language, defined benefit provided by taxpayer applicant or applicant's employer or employers at the time he or she retires in the form of a monthly payment distribution. So it's a defined benefit provided by your employer over which you don't have control, again, so you can't liquidate it in the form of a monthly payment distribution. Insurance policies. Defining language, other than annuities, because remember, we've included annuities as countable assets. We're excluding other insurance policies, which policies are intended to benefit survivors of the taxpayer applicant or applicants or beneficiaries of his or her estate. In terms of procedure, we have the following, and this follows insurance policies. Taxpayer applicants shall be required to execute an affidavit in a form to be determined by the assessor and to submit in support of his or her their representation as to assets, at a minimum, a copy of the last 2 federal tax returns he, she, or they filed, and a copy of the last annual statement received by the taxpayers, prior to submission of his, her, their application for property tax freeze relief for any and all bank, credit union, brokerage, retirement, or other investment accounts, as well as any other documents as required by the assessor. So, last 2 federal tax returns, copy of last annual statement on the accounts mentioned. The assessor has sole discretion to determine whether an asset shall be counted towards the applicable asset limit. After the first year, a claim for such tax relief is filed and approved, and this is in subsection 184-41A3. After the first year, a claim for such tax relief is filed and approved, application for such tax relief shall be filed annually on a form prepared for such purpose by the assessor of the town of North Haven. Any homeowner, this is subsection 4, any homeowner who is qualified in accordance with this section and any such surviving spouse, surviving upon the death of such homeowner qualified in accordance with the requirements pertaining to a surviving spouse, or any owner or tenant possessing a joint interest in such real property with the homeowner at the time of the homeowner's death and qualified at such time in accordance with the requirements of this section shall be entitled to pay such tax in the amount as provided in this section for so long as such homeowner or such surviving spouse or joint owner or joint tenant continues to be so qualified. Language comes from the statute. Subsection 5. Applicants must also be qualified in receiving tax credits under the state of Connecticut elderly and disabled homeowner tax credits. 6. It's important to keep in mind. 6. The applicant must have all taxes paid in full at the time of application for benefits under this article to be eligible to receive said benefits. So if you owe outstanding taxes, you cannot apply, or your application will be denied if you do. The amount of any Medicaid payments made on behalf of the homeowner or the spouse of the homeowner shall not constitute income. That's from the statute. The income of the spouse of the homeowner shall not be included in the qualifying income of the homeowner for purposes of determining eligibility for tax relief under this article if such spouse, this is directly from the statute as well, if such spouse is a resident of a healthcare or nursing home facility in the state and such facility receives payment related to such spouse under Title 19 Medicaid program. Okay, that's in the statute, so you do have that protection as well. The amount of the tax, this is Section B of Section 184-41. It talks about the nature of the benefit again. The tax on the real property for which the benefits under this article are claimed shall be the lower of the tax due with respect to the homeowner's residence for the assessment year commencing October 1st of the year immediately preceding the year in which the initial claim for tax relief is made, or the tax due for any subsequent assessment year. Okay, so the idea is this is freezing the amount of tax you're paying. It is not freezing the payments and allowing you to defer your payments. That's permitted under a different statute. This is freezing the amount of taxes you're paying. So if you're paying $1,000 the first year of the program, okay, if you qualify for this initial program, okay, and you pay $1,000 for the October 1st, 2015 grand list, okay, you're not going to go up beyond that as long as you continue to qualify. That's the benefit we're talking about. We're not talking about freezing payments. We're talking about freezing the amount of tax that you pay. That's an important distinction. There's been a lot of discussion about other programs. That's an important distinction to be made, okay? Subsection C, it's I'm not gonna go through it because I could see people kind of tuning out a little bit on some of this language. It has to do with the transfer of the property, what the process is if the property gets transferred, and it's quite lengthy. One of the things that came up that was of concern to the advisory committee, this is subsection 184-42, application procedures and penalties for false submissions. It's important to keep in mind that in terms of penalty, that is dictated by the statute. So there is a penalty if false information is given to the assessor that can be pursued. And that is in subsection B of that section. Any person who knowingly makes a false application for the purpose of claiming property tax freeze relief under this article shall be fined not more than $500. And any person who fails to disclose all matters relating thereto or with intent to defraud makes a false statement shall refund to the municipality all tax relief improperly taken. There's also a cap. This is something that the committee suggested was necessary. The Board of Selectmen agreed. The proposed language is at 184-43, subsection A. Prior to the application deadline of May 15, 2016, at a meeting of the Board of Finance, the Board of Finance shall establish a maximum amount or cap for the aggregate amount of benefits available under this article for the first year of the property tax freeze program created herein. Thereafter, the Board of Finance shall establish an annual cap for the program in January of each year, and establishing the cap, the Board of Finance shall consider the anticipated receipt of federal, state, and other funding. In the event that this is subsection B, in the event that the cap is reached, the available benefits shall be prorated among qualified applicants as determined by the assessor. So what's proposed is the Board of Finance, because it was believed by staff, and that this was recommended language coming from discussions with staff, that the Board of Finance is in the best position for establishing the maximum amount of benefits. Eligibility for other benefits. 184-44, just because you qualify to receive this relief doesn't mean you're disqualified from receiving any other relief for which you may qualify. So that's included in there. So can you get the credit and the freeze? Yes, you can, okay? Severability of provision, something we always put in section 184-45. If any provision of the article is found to be invalid, it's not going to invalidate any other provisions. Sunset provision, as it's known. Section 184-46, term of the property tax freeze relief program. This article shall take effect 15 days after publication of the article in a newspaper having circulation in the town of North Haven, and shall remain in effect through the current revaluation period, which ends with 2019 grand list. I mentioned that at the beginning. It's included at the beginning and referenced at the beginning as well. The assessor will not accept any applications for property tax freeze relief pursuant to this article subsequent to May 15, 2020, unless this section is amended by the town meeting. So that is the sunset provision of this ordinance. There are other towns that have enacted freeze programs for a year so that they could evaluate the impact of the program and such, and whether or not it was being used. But we're going to have it go through the end of the current revaluation. So I don't know if the assessor or I know the finance director is here as well, if they want to make any additional comments. That's the language proposed. Happy to answer any questions. We've been working on this for some time. And I just want to say again, I cannot say enough about the advisory committee. I think they were great contributors to what is presented tonight to you. They were given a lot of information, not only the statutory language, but several samples, as well as other information that's out there in terms of the relief programs that are offered by other towns. I think they were thoughtful. They really showed every week. I mean, we had 4 meetings that, they wanted to act in the best interest of the town and not their own personal interest. And it was just a great exchange. It was a great thing, and I think it resulted in some good language. That's all I have to say. Thank you for listening. I know that was long, and I appreciate it. This is something I've got to do so that you're informed. I want you to be informed about what you're voting on. Okay, thank you so much.
Before calling on members from the general public, I will allow the selectmen to comment, and we'll first recognize Selectman Mr. Doheny.
Good evening. I'm Tim Doheny, 319 Knight Lane. I'm a member of the Board of Selectmen, along with Ms. Boehme and, of course, our first selectman, Mr. Frieda. Just make a couple of quick comments. Jen did a nice job going through the details of the program for you, but I'll just make a couple of quick comments, some of them which will be repetitive. But first of all, this has been a big push of the towns. There's been a number of people who have come to the Board of Select meetings asking for senior tax relief. Mike has promised to look into it, and now, of course, we have the program that's in front of you. We've had quite a lot of conversation about it at the Board of Select meetings, and some of the things that are in here are driven by the state statute, which Jen did point out. I will tell you that they were the subject of some conversation at the Board of Select meetings. So just to give you an example, when it was first presented to us, one of the first things that the three of us collectively said was, well, why age 70? 65 just seems like a more natural cutoff. And that's probably the preference of all three of us. But unfortunately, it's driven by the state statute. The same is true of the income limitations. Those are driven by the state statute. So we tried to put together something for the town that we could, given the framework that we were given by the state. The one big change there were several big changes, but one of the big changes that was made was that when it was originally discussed, there was going to be the so-called clawback, meaning you would have had to repay any amount of tax that was deferred, either when the homeowner passed away or the house was sold. But Mike committed, after some conversation, to take that out of the ordinance, and it's no longer there. And we are one of the few towns in the area in the state that does not have the clawback provision. The other item that came up was the asset limits, and Jen just talked about those a minute ago, and Mr. Katz is here, who chaired that commission with a number of other members, but it was felt that we should only offer this to people who were truly in need, so the asset test was driven out of that. So there was a lot of conversation at the Board of Selectmen meeting about the program. I think there was some call that it might be a little bit more expansive than it was, but we really tried to work with what we had, and this is it. Now, the other thing I'll say, and I'll give this as not a teaser, but this is the third program we have in town for senior tax relief. I'd have to refer to Gary to tell you about the other two, but this is just one of 3 programs that we have if this were to pass tonight. So I know there's probably going to be a lot of questions about it. I know that some of you out there probably think there are some limitations, and you're asking yourself, well, why isn't this a little bit better? Why are the income limits so low? Why is the age so high? But again, it's because we have to do things according to state statute. But the 3 of us, I think I can probably say, Sally can certainly speak for herself, and so can Mike, but we are supportive of what we have here, and we think it will benefit those who do qualify. Thank you.
Thank you. Do either of the other selectmen wish to speak? Ms. Boehme?
Good evening. Sally Boehme, 5 Blossom Drive. First, I'd like to commend the first selectman for taking the initiative to put together or to promote a tax fees program for the elderly. And I'd like to thank my fellow members of the Board of Selectmen. We did work together to try to put together the best proposal we could. We really started last fall. And it, the whole process kind of reminded me of the tax incentive ordinance we passed a couple of years ago, where the 3 of us really put aside the R's or the D's after our names and really tried to work together for something to benefit the town. And I think that's what happened here in this process. I'm not happy with everything in the ordinance, and as Attorney Coppola and Second Selectman Doheny said, we are sort of restricted by, we are definitely restricted by the language of the statute. State statute trumps local ordinances. Well, maybe I shouldn't say trumps. Did Tim laugh? My goal in life is to make Tim laugh. Did he laugh? But anyway, the asset limits we're stuck with because that's what the state statute says. I also wasn't happy with the age 70, but again, the state statute says that's what it has to be. But I think this is a good first step. We'll see what happens. We'll see how it plays out, how many people apply, and then we can make determinations in the future if any changes are necessary. The asset limit, I talked about at the special Board of Selectmen meeting on March 21st. I unfortunately missed the March 3rd Board of Selectmen meeting where there was a more extensive discussion of the proposed ordinance. But at the March 21st special meeting, I did say that I had some concerns about the sliding scale for the asset limits. Now keep in mind, the higher the asset limit, what that means is you could be richer and still qualify, okay? And what the sliding scale says is if you're only here for 5 to 10 years, because remember, everybody has to be here at least 5 years. But if you're here in North Haven as a resident only 5 to 10 years, your asset limit is lower, which makes it more difficult to qualify. And then it goes up to a second stage, and then if you're here over 20 years, it's a higher asset limit, meaning you could have more money and still qualify. I do understand the theory, but I just don't think it's quite fair. And when Attorney Coppola made her opening statement, she read the preamble, so to speak, of the ordinance, and it says fair and equitable in there. And I just find a sliding scale of asset limits just a little unfair and a bit arbitrary. Now, I've been here 59 years. I'm 59 years old. I've been a homeowner for 30 years. So it doesn't affect me. I would qualify, I would have the benefit of the higher asset limit when I'm 70 in 11 years, which is frightening to think about. But I just think that if the goal is to help people, elderly people who are currently in need, whether they've been here for 5 years, 10 years, 20 years, if they're currently in need and they qualify otherwise, I don't think having this sliding scale of asset limits is fair. It just doesn't seem neighborly to me, for lack of a better word. And I just find it a bit arbitrary. And basically what we're doing is we're treating people who are otherwise similarly situated a little bit differently, depending upon how long they've lived here. And as I said at the Board of Selectmen meeting on March 21st, local government provides services to the community. You know, education, police, fire, garbage pickup. And if you've been here less than 10 years, you're not told you could only put one garbage can out there, you know, and then when you're here 10 years, then you could put two. You know, we don't make distinctions like that with our services. So the sliding scale didn't seem quite right to me, but I do understand and respect the theory behind it that the esteemed advisory committee had when they proposed it. And as I said at the beginning, this whole process has been very cooperative between myself and my fellow members of the Board of Selectmen, the advisory committee, Attorney Coppola, Assessor Mr. Gary Johns, and I think inherent in any governmental process is a sense of compromise and cooperation. And so I approve this ordinance as is, even with the sliding limits, in deference to the advisory committee. And we'll see how it plays out. And if we need to change it later, we could. But right now, I support this 100%. I think it's a good starting point. And again, I commend the First Selectman for taking this initiative. Thank you very much.
Thank you, Ms. Boimey. Before turning this open, and I'll be calling on people to come down and speak, I would like to say that each person who wishes to speak has the right to comment, and you have the right to ask any question you want. What you don't have is the right to have the answer if you can't compel someone to answer it. I suspect that of all of the people we have here, from our town attorney to our finance director, to our first selectman and the other selectmen, there'll be more than enough people who wish to answer your questions. And so rather than having them answered at the time you ask them, I will ask at the end if they write these down and someone wishes to come forward and answer any questions. With that, I believe there was someone on the left side here.
My name is Sheldon Messinger, and I live at 53 Meadowbrook Road. And I have just a couple of comments or more questions than anything else. I think the thing that rankles most of us about this is the business that there's no take back. A person who has a house worth $500,000, dollar less than that, who dies, his relatives get that house, and no matter who they are, where they live, what their assets are, what their incomes are, they don't have to pay it back to us who have given that benefit to those people who need it. The other thing, and I think this is we're stuck with the state statute, I can't conceive of how our legislators could say, hey, if you couldn't pay your taxes last year, you don't get the benefit this year. I don't have an answer to that. I'm sure you don't either. Those are my two concerns. Thank you, sir.
Thank you, Mr. Messenger. Yes, in the back.
Donna Levine, 23 LeGrand Road. I've lived in North Haven 9 years. We didn't send our kids to the schools. I'm not looking for any kind of rebate for myself at all. However, I'm very uncomfortable with the ordinance. In my professional life and in my volunteer work, I'm an advocate for the elderly. That's my job, that's my calling. And I do want to do the right thing for our seniors, and I'm also a senior. But there are too many loose ends, I feel, in the ordinance, with all due respect to the people who drafted it. And I just was sitting here making a simple list of some of the things that I thought were loopholes, we might say. One, there's, of course, the no payback. That's the first thing. So I'm not sure if the reason for the ordinance is to help our poor seniors, why are we helping our poor seniors' heirs? I don't understand that. And the same thing with, as Ellie talked about, the increased asset limit for the longer people lived here. I mean, why not an increased asset limit if you sent your kids to private school and didn't use our services or any other criteria? It just seems like an arbitrary criteria. So those things bother me in thinking about what is the primary purpose of this. It's to help people who need help. Well, if it's to help people who need help, why not the poor, the unemployed, the disabled, all sorts of other classes of people who might need help, and not just someone over 70 with only, what does it come to, a maximum of about 700,000 or 800,000 in assets, including their house, might be eligible for this. It doesn't sit well with me. I also thought that, I do Medicaid applications as part of my work, and I know how much work it takes to put together the documentation and whatnot. I think the town's going to need an employee to process these applications and determine if they're accurate. I don't know, they were talking about 200 to 400 applications where you're having to look over everybody's assets and all of that kind of stuff. It seemed like, who's going to do that? I don't know how the assessor's office feels about this if they have that many hours to spare to do it right. The fiscal impact hasn't been determined at all. I was glad to hear that there was going to be a cap set, but we don't know what the cap is and how poor people in town, and I'm fortunate not to be worried about myself, but poor people in town might pay a higher tax to enable a senior who has hundreds of thousands of dollars to pay a lower tax. It just doesn't make sense to me. Especially, I mean, I think at least a study of what the fiscal impact will be, the first year to determine that, and then go from there before it's sort of put in place for many years to come, and we don't know how it'll affect people. There's some little things, this isn't, and my list isn't in any particular order, but things I noticed. One, the exemption for life insurance. Well, people can put a lump sum, a couple $100,000 or more, into a life insurance policy. If you're not counting the cash value of life insurance, you've got a loophole right there. And I mean, I'm a lawyer, I look for loopholes, and this is my field. It was rife with loopholes if people wanted to reduce their assets in some way. Granted, their income has to be below a certain amount to start with, but they could have mega assets. There's no look back for transfers of assets, like with Medicaid. If you give it away within 5 years, it comes back at you. Here, if you have 500,000 plus your house, and you say, gee, I'm low income, I would qualify for this if I give away 300,000. You give it away, and the next day you trot down to town hall and apply. If you've been here 20 years, and you can have. So that was the thing. The penalty for false information was $500. Not too many people are scared of that. It's a very low, you'd think you should have to go to jail if you lie or something, but a $500 fine for lying and getting the benefit made me a little bit concerned. You talked about statutory income limits, and I think I'm a little familiar. I think it's like 48,000 for, I wasn't sure which income level limits, but they're low, but they're not that low. So if you have a family, a married couple with an income of 48,000, a $500,000 house, and a couple, 300,000 is at the top, I forget, for someone who's been here 20 years, and you're gonna freeze their taxes and never require them to pay it back. And poor people in town are gonna pick up the bill for that, as well as people who can afford it, but whoever picks up the bill for that, it just doesn't, it doesn't seem as well thought out as it needs to be. Also, from what I've read, we're already one of, if not the oldest town in Connecticut. So why, and again, I am an advocate for seniors, but why do we want more seniors in town? Why are we giving seniors per se a benefit? Why not Black people or, you know, any other sort of group of people that maybe we want to encourage to be in town? Why not offer them a benefit? It's sort of I always feel guilty when I go to the movie theater. I take my benefit, but I always feel guilty when I get the senior discount at the movie theater because I could afford to pay full price, but all seniors get the discount. So there's a lot of that already. But to have it on the backs of other people in town who can't afford it, you know, makes me the most uncomfortable. So I think it should go back for more study. I think if there were a payback, it might be more palatable, because at least the town, you know, the fiscal impact wouldn't be long-term. But I think it's premature to approve it for this year. I think it should go back for more study, and I think I should be on that committee.
Mr. Katz.
Sherman Katz, Sherwood Drive, member of the advisory committee. And I just want to hit a few highlights here, probably more than I should. The first thing I want to mention, I spoke to Gary Johns, who was our assessor, and I tried to get some figures on what this would cost the town. And some of you people think it's going to cost you hundreds and hundreds of dollars a year. And the figures that we come up with preliminary are, it's going to cost a resident $4 per year to support this program. Is that right, Gary? Is that where we came, roughly? In that area, okay, give or take a few bucks. The first year, yes. Now, this is only for good until the next reval. It will then be canceled and has to be renewed, reworked, or approved. So we have 4 years for till the next reval. And at that time, if you feel it's not right, you don't vote for it. But I just want to impress on people that think this is going to be extremely expensive. This young lady that was just up here indicated it was very costly. Well, $4 a year is a half a pack of cigarettes, 2 bottles of beer, 2 gallons of gas. And if you can't afford to support people for $4 a year, there's something wrong with you. The median income in this town is over $70,000. Now, I want to try and answer some questions before they come up. The question about the sliding scale, I'm going to start out by saying that the seniors that have been in this town for 20 to 50 years came here when the town of North Haven was a blip on a map, not much more. When my father said to me, I need you to go to North Haven to get something, this was 60 years ago, I said, what's North Haven? He said, get on State Street and keep going. Right. Many people moved into North Haven when it was a farming town with some industry. They built and paid for the police department, firehouses, schools, libraries, Walter Gur's swimming pool complex, the public works department, the wastewater disposal treatment plant, and the sewers, and probably many, many more things. Many of these things were done 30, 40, 50 years ago. You people here never paid for those. You're paying for the new schools now, yes, but we're still paying for the new schools too. We work very hard to provide the best education for the children of North Haven that we could. Seniors never turn their backs on education. Sometimes we were accused of turning our backs on education. Not true. You wouldn't have the schools that we had today if the seniors got together and said, we don't want it. Coming to the sliding scale on the asset limits, I'm going to use an analogy here. Many of us have worked for a company where After 1 year or 2 years, you got a week's vacation. After 5 years, you got 2 weeks vacation, and so on until you were lucky enough to get 5 weeks vacation. The reason you got that was because you were being rewarded for helping the owners of that company build their business and make it a success. I would suspect if you said to the town workers in North Haven, you're only going to get 1 week a year, no matter how many years you work here, you'd have a revolution on your hands. And we're loyal. We've been here. You don't have to die to move out of your house. You said that when you die, your heirs will get the house, and they can sell it, and therefore you should have paid the taxes on it. Many seniors move into senior complexes. They sell their house, they have a few dollars left from the house, and they go into some kind of senior or age-restricted living, usually income dependent. A lot of the things that we had to do was because of state statutes. I didn't argue, I requested higher income limits, and I was pretty stubborn about it until Jennifer convinced me, and Mike, you also convinced me, that we had a state statute to abide by. Certainly, you know, $40,000 a year is not a great amount of money. And you'll all know that it's almost impossible to live on $45,000 a year unless you have your house completely paid off and you don't go out of the door very often. I'm just about finished. I want to say that the 9 members of the committee worked very hard. We had 4 meetings. These were public meetings. The public was invited to attend. The public was, at the end of the meeting, the public was invited to make comments. We had 3 employees from the state, from the town. It was Gary Johns, our tax collector, and our Ed Swinkowski. They were helpful in advising us directions. Jennifer, the legals, I told you before, you couldn't beat her. We had the tax programs from 15 or 20 cities and towns in Connecticut that we all read and studied, a stack about that high, and looked at what they were doing. We have no clawback. Originally, the plan that was submitted by the selectmen was to have something with a clawback, which hit a stone wall. And they came back with another program with no clawback. We're sort of trailblazers. It's not expensive. And again, you can knock it out 4 years from now just by coming back here and saying, I don't want it. And I just want to thank all my committee members. They worked really, really hard. Thank you.
Thank you. Mrs. White?
Mary White, Summer Lane. The first thing I wanted to say was that I'm definitely in favor of helping seniors who truly need the assistance. And I think what we're trying to do is we're trying to balance wanting to help the seniors who truly need it with the cost to the rest of the taxpayers. I have some suggestions, and I don't know if it will make any have any effect as to what happens tonight, but one of the things I thought, this actually, the way it's all turned out, excuse me, has got me nervous as far as like the cost to the town, because there's just so many unanswered questions. But a suggestion I had is in the application process, it says in the proposal a 2-year look back of the tax returns. I would suggest could the tax assessor ask for a 5-year look back, or it's 2 and only 2? How solid is that language in the proposal? Can it be at his discretion or something like that? As far as the program cap, that's to be set by the Board of Finance at a different time. that really bothers me. For us to, it's kind of like going blindly ahead. We're not really sure, what the financial impact will be, and the program cap is not even known right now. So I am kind of resistant to to be in favor of this, not having some information such as the program cap that the Board of Finance is going to determine. As far as like the term and the whole life insurance policies, it says that they're not included, but I'm wondering again if at the application process, if those policies can be shown that they are in existence, just in case there's withdrawals that can be made of their cash values. And so as far as like the potential, the $4 per taxpayer, I kind of went from it from a different mathematical point of view. I used a lot of estimates, so forgive me if I'm way off, but I was thinking, if you ever watch any of the Board of Finance meetings and the budget workshops, it's just amazing just how much there's needs in every department throughout the town. The town side of the budget, the education side of the budget, and it just seems like, with the cost of everything going up, there's just so much, it looks like the mill rate's heading up, really not heading down. So what I did was, okay, maybe we have, I estimated 300 per people participating in this program, the mill rate goes up, and let's say blanket, again, it's a very broad estimate, say everybody's taxes went up $200, let's just say. So multiply that out, that's $60,000 for the first year. Let's do the worst case scenario, that the mill rate keeps going up every year, and it goes up again by $200. Obviously, it could be more, it could be less. And we get all the way to looking at the fifth year at $300,000. So I just think that the cumulative effect should be taken into consideration. We don't know if it would be anywhere near 300,000. Could be less. We just don't know. There's just so many unknowns, and so I just kind of think that at least, the very least, what we should do is wait and have the Board of Finance set this cap. And anyway, also I am not really pleased with that sliding asset scale. That bothered me. I think that just to have the, obviously 5-year residency requirement for sure, but just to have like the assets, like 150,000 for single, 200,000 for married, and have it the same for everybody, I think that that's fair. So anyway, those are my concerns.
Someone here, yes, in the front, next to Mr. Katz.
Once again, Dave Yench, 61 Blakesley Avenue. I've lived in town for 69 years, which coincidentally is my age, so I will be 70 this year. Is this on? I've lived in town for 69 years, which is also my age. So I'll be 70 this year. I came here this evening thinking I'd probably benefit from this, but not being a Philadelphia lawyer, the excellent explanation, I realize I'm not going to benefit from this, and that's fine. But I'm in favor of this program in principle. A couple of concerns I have are the length of residency. I think this should be for our seniors who have been in town for long periods, maybe, like 20 years. I don't think 5 years is enough to really consider yourself a North Havener. And also, I don't think there's going to be a huge impact on the revenues to the town. If it's going to cost me a couple of bucks extra, $4 or $10 or $20, I don't think it's going to make anybody go to the poorhouse. Also, I don't quite understand, if you've got an income of, what was it, $40,000? 42. and you've got a home that's worth $500,000 and you would still qualify, possibly you shouldn't be living in a $500,000 house. But that's me, what do I know? Also, I discovered this evening that didn't know it before, I just discovered I'm elderly now. Says it right here, but that's just my 2 cents, thank you.
Mrs. Mazurek?
Joe Mazurek, 154 Cloudland Road, North Haven. I have some comments on this new program. First of all, I think the senior tax-free program should be called the Senior Elimination Program. The eligible age is 70, not 65, as you know. The income levels from the state circuit breaker program of $35,200 single to $42,900 married is as low as you can go. That eliminates 3/4 of our senior population. We have 303 seniors out of 4,762 in town who are eligible at those income levels for our current program, which starts at 65. So who else will benefit with this new program? Nobody. The most important criteria was the income level and the age, and that was cast in stone by the statute chosen by our attorney, Coppola. The committee was limited in only assessing assets, and that's all they ruled on. And common sense, this $500,000 house, who earns $35,000 to $42,000 a year and can afford a house that expensive? That's a fallacy. You can't. You can hardly live on that money. So I don't even know why they chose that figure. And ironically, the second selectman questioned, at the second selectman meeting, the low income level as well as a member of the committee. The member of the committee stated the veteran's income level could be $67,000, and yet we're saying $35,000, $42,000 for seniors. And, he wanted it raised. Well, someone on the committee shouted, well, they earned it. Well, I have a brother who was a pilot and a retired U.S. Air Force lieutenant colonel. And I have the utmost respect for the armed forces and feel that was a cheap shot at the seniors. And there is an additional local optional tax-free plan for seniors, which the committee could vote on and a town ordinance could be established. It could be set up for seniors starting at age 65 with a sliding income scale according to residency or one income, perhaps $55,000, for example, for all the seniors. I have discussed this program with the town of Guilford, who has this program along with 6 other very good programs, and some are the circuit breaker program with a limited income. But this program is unlimited in Guilford. And the only requirement from seniors is their 1099s and W-2s to show their eligibility. They trust the Guilford seniors. They're not arresting them either. There is no payback or liens on the property. While the Guilford plan is very expensive, it goes from a low of $29,000 for single to a high of $95,000, which would be unheard of in this town. They are a higher income town. But in accordance with our income levels throughout town, I do not think $55,000 or in that range would be too much for the seniors to be earning. I have been told by our statute quoting attorney we are not eligible, which is not true, and also is too expensive, which I explained it is if we follow Guilford to the letter. But talking a much lower range in the 50s might be manageable in our town. And for those of you who think that any amount of tax relief given to the seniors is too much, I have a few stats I'd like to share with you. We have 4,782.65 seniors, translated into 2,391.33 young couples with 2 children in our educational system. At $14,500 per child, $29,000 for 2, equals $693,485.70. Special needs set aside at 60. So we're paying over 693,000. We would be paying 693,000 if the seniors that we're speaking of were young. They're paying nothing for us. We paid it, and we're still paying it, and we have never complained. Now, if our current 303 seniors go on this tax freeze program, which they're already on the program, and our taxes are raised, perhaps 200, it would cost the town $60,600 for these seniors. Then, if they raise the income level, as I have recommended, with the program I suggested, and maybe pick up another 100. So now we have 403 seniors. It would cost the town $80,600. And as far as Mary was projecting ahead 5 years, if we were paying $300,000, it's still not costing the town $693,485.70 as young couples would. And you don't have to worry about this going on forever and ever, because as you know, attrition will set in. We won't be here. And someday, who's ever here, I don't see many young people here, and someday you will all be eligible in town if we set a good program. I feel the program being presented tonight should be voted in for the very few who can benefit by it, and it is very few at the low income. But a new committee with a new attorney should be formed and add the program I have suggested with a higher income level for our seniors, future senior tax freeze programs, because we are really not benefiting many people, and I think that would be a good idea. And I also have included here, the town of Guilford has just sent out their mailings for the people that are going to be on their program. And they have listed on their program, let's see, disabled program, a veterans program, state freeze program, state elderly program, and the programs that say state in front of them are at the $35,200 level and $42,900 level. That's how Guilford has it. So there are low-income programs that Guilford is giving. But the tax freeze program that I speak of, the income levels are from $29,000 for single up to $95,000 for married, which, as I said, we won't even think of that in our town. But Guilford calls this a town elderly tax relief program. And they also have for the veterans a town program. And when they say town, that means they didn't go by the state statute. I'm so tired of hearing state statutes all night. Everything is state statute. You can't walk without the state statute. Well, they're not going by the state statutes. The town has their own program. And they also have state programs, and that's where they're going with that limited income. So we have the option of bringing in another program that I think would be a lot more fair to our seniors than that one. And I am for this program because the few people that benefit from it with those incomes should benefit. But I would like to see another program set in place for the many people who need it and are not getting any relief. Thank you.
Thank you in the back. Red vest. I can't recognize you from here.
Good evening. Sid Levine from 23 LeGrand Road. I think this was a very well-intentioned effort, but I do have a couple questions. One is, I'm not really convinced that, maybe it's not a question, maybe it's a statement, that we know actually what this is going to cost. I've heard different figures thrown around, but I'm not quite sure what that means. And I know one thing that it means is that When some people pay less taxes, more people are going to pay more taxes. And the question is, what is that actually going to look like? The second comment, and I will be brief, is that I don't understand the rationale, quite frankly. I don't like the term clawback. It sounds very nasty in a way. But reimbursement, I don't understand the rationale for not having people have to repay what the town has extended to them in a tax benefit when the house is sold at that point in time when it really doesn't impact on that individual. And it seems like, from my understanding, that most of the area towns do have a reimbursement, and I'm not sure why the committee decided to be so generous about that wasn't the case. It seems like the only people that benefit from non-reimbursement are the people who inherit the house. And that would seem like a very good timing in terms of the town to get some of its taxable monies back. As I think we're all aware of, lastly, for the next fiscal year, the state of Connecticut is going to have, they're estimating, and maybe low, $900 million of a shortfall. And that's going to have some direct impact on the town of North Haven. I mean, it's impossible to believe that that wouldn't be the case. So, you know, how is that going to play out in terms of taxes? We have yet to see that. But I think it would be very fair if people had to, you know, when a house was sold, pay back the amount. I mean, people have lived in North Haven for many years, and you would think that they would feel, I certainly would, a need to have some fairness here. That's all I have to say.
Thank you. Yes, the middle here.
Leonda Fermo, Juniper Drive, North Haven. This is a question for Jennifer. It says here that defined pensions would not be included as income. Does that mean people who are on corporate pensions, state pensions, town pensions will not be included as an asset? It is included as income. Okay, but not as an asset. Okay. My other thought is that it isn't just the poor people in town that will have to pick up the remaining of the taxes. It's also our young people in town who will have to do it, who are pretty stretched out. If you have children living in this town, you know how hard they're working. And they will also have to pick up the balance of the taxes.
In the last row.
My name is Eleanor Pirelli, and I live on Clintonville Road in North Haven, and I have so for 45 years. Yes, we had children in the school, but at the time our income was low. It was appreciable. So we were talking now about young people here now, and they have children in the school that cost money, but they are making so much more than I ever made. Okay? The other thing is, pass a law and then think about changing it? No. Once it gets passed, it's passed. You make the changes, make everybody understand it's what they want, then you vote yes. okay? And as far as having a lien on the house or whatever, I think that you really need to look at that. That's perfectly fair. I mean, I have just had to go through probate for my husband, and let me tell you, there's all kinds of questions there. And there's nothing wrong with having a lien or something on your house. It's true, who is going to benefit? And you need to pay it back. If you're going to get it, then why should you care? You know, but you don't want to put a lien, you don't want anybody to put your lien on your house. And then, my question is for all these people, how much money are we going to have to get to pay all these people to do an honest assessment of everything and make sure it's correct? And just saying the clause, well, if you make a mistake, it's $500, that's peanuts. You know, come on. Who, you know, everybody is honest? Oh, what? What do they say about the first person who is honest? Please stand up. Very good, glad you are. So you don't mind if you have to pay back for the taxes that somebody else might have? I think there should be a lien because the only ones who would benefit that is... That's true. That's true. That's true. No, I don't mean that in that context, but what I'm saying is that not everybody will put everything down. And when I had to do the probate, I had all these papers, and she said, and I went through weeks of getting all these papers to show that this was correct. And she said, oh no, we don't need that. You just sign here, we take your word for it. I said, well, thanks a bunch. You know, after I've gone through. No, but you don't, no. I had everything down, but the thing is that everybody knows when they do this, they should be honest about it, because you're only cheating yourself in the long run.
Please.
Well, and everybody else. But anyway, I oppose this ordinance, and I wonder how, is it just going to be an A or, yes or no? Are we going to count the votes? To make sure everybody got, and I'm just shocked not to see so many young people out here. Apparently they don't. They're working two jobs.
Please, order
okay.
here, only
All
one
right.
person speaks
so they're
at a time.
working two jobs. But, when we came here because we figured out our budget and we could afford to live here. If the young people coming here today cannot afford it, looked at the budget, then don't come. 45 years.
Please.
Okay, so that's it.
Excuse me, respect the speaker. This is not a time for response. Each person gets to speak and gets to be listened to respectfully, no matter their message. The man in the dark vest, please.
John Hedden, I live on Spring Road. I've been here 12 years. I figure that I've spent on taxes about $75,000 so far. Half of that went towards schools. I think the education budget is about half of the total budget for the town. I have no children. I've gotten no benefits basically from that. I don't begrudge it, but by the same token, I think that having reached the age of 79 years old, maybe I'm entitled to a bit of a break on the taxes. And the way it's written right now, if I get Social Security, if the limit is $35,000, that means I could only earn $15,000. I'm getting, $20,000 in Social Security. I can only make $15,000 in income. Means I don't qualify under the program as written by the state. As far as the clawback is concerned, everybody's talking about not people selling their house, people dying and someone inheriting the house. What often happens with seniors is They sell their house because they don't need such a big house anymore. They're downsizing. They need every penny they get in appreciation on that house in order to buy something that they'll be able to afford. So it isn't heirs from California coming in and swooping in and picking up a big benefit. The clawback, I think, makes a lot of sense. Without the clawback, they're not giving us anything. If they're saying, okay, here it is, but you got to pay it back sometime. And if you sell the house in order to buy something else, which is more likely to happen, or it's as likely to happen as dying. If you sell the house, you need as much of the money as you can to buy something else. So I'm fully in favor of not having a clawback. I mean, if you take the clawback out, you're not giving them any. You're not giving us anything. And secondly, I think the income limits are unrealistically low. I'm not talking about a $500,000 house, but a $250,000, $300,000 house. You know, the taxes are $6,000 a year. I moved here because of low taxes. And now it's getting to the point where they're not so low anymore. And I think it's time. I could use a break, frankly.
Thank you. Gentleman over here in the third row, fourth row.
Pat Violano, 2 Horseshoe Hill Road, North Haven. I'd like to ask Attorney Coppola, if you have a mortgage on your house, senior people do have mortgages, is this going to be included for this tax freeze for us?
Once again, rather than having a discussion, you can state your question and it will be answered when they have
I'm stating the question.
No, rather than a conversation that you're having with them, you can state the question and it will be answered when they take the microphone, okay?
You have a mortgage on your house. Will this be included in for us if you want a tax freeze? I've been here 43 years, so is it included?
If you wish to take the microphone, that's fine, but this isn't a time for back and forth discussions. What I said was you can ask a question and it will get answered. You seem to be demanding that the moment you ask it, it have an answer for you.
In terms, I think the question that you're asking, if I'm understanding it, and I will get up to the microphone because I want to have a clarification from you rather than bringing you up after. I think what you're asking is in terms of the asset limit and the countable assets and the exclusion of the fair market value of the house up to $500,000, are we taking into account in terms of the determination of whether or not you reach that exclusion, the mortgage on your property? And no, it's strictly the fair market value. We're not looking at whether or not you have a mortgage on the property.
Okay, do we get papers to file, or do you have to go to the town hall?
There is going to be an application that you will need to submit, yes.
There will be an application.
And it will be available for you to fill out when the program takes effect.
Okay, that's all I...
And it is the intention of the assessor as well. There are currently 389 people who are on the credit program. It is the intention of the assessor to send applications to the folks that we know, and then the number is 303, who do reach that age requirement, do meet that age requirement. So he is going to actually send out notices to those folks. And hopefully, you know, this has received a lot of attention. There may be a number of you know, other folks that are going to come forward and want to apply. I just want to make one quick comment too. I want to caution people when they talk about, you know, what is the cost of the program. Ultimately, we can never know the answer to that question because we don't know who's going to come forward and apply. And that's important to keep in mind. I think in terms of talking about figures, we're talking about, and the assessor can add to this if he wishes. But we're talking about, basing, in terms of discussions that we've had about the projected cost of the program with some of the people that have inquired, like Mr. Katz. We're talking about looking at the people who currently are getting some form of benefit. We don't know ultimately, who's going to apply for this program and whether or not they're going to qualify. So that's important to keep that in mind.
When will we expect these folders to come to us?
The application period, and this is in the ordinance, but the application period is tracking the other program. So the application period will actually end May 15th. It is going to run from February 1st to May 15th, similar to the other program. And I don't know the specific date that the notices will go out. I don't know if the assessor wants to answer that question.
Okay, in case we do not receive anything, shall we go to town hall and request one?
The process that we're going to be using is that if this ordinance is approved tonight, we have a letter with all the requirements that are in the ordinance that will be sent out to those that are currently receiving benefits. We will start taking applications in the office on hopefully next Monday, and that will go through May 15th. I'm going to do appointment only, so anybody that's interested in applying for the benefits, please call the assessor's office in the town hall, and we will set up an appointment for you, because it's going to be a more complicated process than we've gone through with other benefits in the past because of the asset limits. So we want to spend some time with the individuals and going through their documents.
So we have to call and make an appointment?
Yes.
Okay, that's good enough for me. All right, thank you.
Gentleman with a baseball cap on.
Jay Bard, Sherwood Drive. First, I would like to say that in general, I agree with the intention of this ordinance, and I'm happy to see that there are certain things that were added here that would be good, such as a penalty for a false application and the sunset provision. I'm a little ambivalent about the maximum amount and the Board of Finance setting a limit. And one of the problems I don't think people are understanding is that this is supposed to be something that's supposed to address a need, not what people deserve, but a need for people to be able to stay in their homes. And what's going to happen is that this is going to grow exponentially. The first year, maybe taxes go up $100, and you take the number of people who are eligible, and it's going to be that number of people times $100. The next year, as taxes go up again, just for argument's sake, another $100, then everybody who qualified is now eligible for saving $200, plus any new people saving an additional $100. And this is just going to keep on growing year after year after year. And then you're going to have to set a cap, and then you're going to have to say to people, well, we can't give you this full benefit that we said we were going to give to you because we can't afford it. But if you have a clawback, as they use it, then over time, eventually we would be recouping this money. And we would be able to afford to give people the benefit that we want them to have. And a couple of other things that I wanted to mention was I agree with a lot of the things that some of the other people were saying. For example, I think the look back should be longer. And as Mary White had said, she was looking at income, and I have a little issue with that because somebody may have been working 5 years ago and they just retired, and now they're trying to live on a lower pension. So I think the idea of just having 2 years for that would be good, but I think you should go back 5 years as far as looking at the assets as Medicaid does, so that you don't have people who are looking to cover up their assets. And I think that there was a loophole that somebody else pointed out, that you can exclude insurance, but not to the extent that there is any cash surrender value, because that is one tool that financial managers use, is you can buy paid-up life insurance, and it's a way of sidestepping this issue. And one other thing is, I think a slight oversight, there's a redundancy in talking about the asset limit in which you say that you're gonna exclude the home up to $500,000. The up to $500,000 is redundant because if it's over $500,000, they wouldn't qualify anyways.
Yes, one comment here, maroon shirt, please come down. You just had your hand up, yes, come down.
I'm Ed Moran. I live on Marion Court, and I've been a tax-paying resident of the town of North Haven for 48 years now. And yes, I am over age 70. I would like to thank the first selectman for this incentive. I would like to thank the committee that worked so hard on trying to come up with a resolution that we could all live with. But unfortunately, I feel that it is inequitable, and I am going to vote against it tonight. There are several reasons why I am against it, okay? A person that has an estate of $750,000 should not expect the other taxpayers of North Haven to subsidize his lifestyle. I believe tax should be deferred for all seniors if they elect it, but it should be deferred, not forgiven. The intention is to help the seniors and not to help their heirs. The asset calculation seems to be a little unfair. If a person has a retirement plan that is a 401k, its value is considered an asset and could disqualify the recipient. Yet, if he has a defined benefit plan that could be worth far more in the long run, he is not disqualified, okay? So I think that 401k should be treated like any other retirement plan. Okay. Thirdly, the plan is supposed to help seniors that cannot afford to pay taxes. Those seniors that cannot afford to pay them now and are delinquent do not qualify for the plan. Is that fair? Okay? The other thing, though this, obviously, the benefits of this plan is going to be exponential. It's going to cost us more money each year, but it also has an inflationary aspect to it. If I am going to a budget referendum and I'm a senior and I don't have to pay any more tax increases, I would say, yes, build the best senior center in the country. I don't have to pay for it, okay? The man that questioned the value of his house a few minutes ago, suppose a person has a house that's worth slightly more than $500,000, but his wife or his spouse was sick. He has big medical bills. He took out a mortgage on it to pay the medical bills. Now the house is still valued at its market value, or should it be valued at the equity that the person has in it? Okay? I had a couple of other topics, but as you can tell, I'm not used to talking, and I did not prepare anything, but I hope you take my thoughts into consideration. I am one senior that's going to vote against the plan tonight. Thank you for your attention.
Thank you. Seeing no one else, I'm going to ask Mr. Kachewicz to speak again. Is there anyone else who wishes to speak again? Because I want to call the question after we have this, after you're finished with your comments, okay?
Chairman Cash, Sherwood Drive. I just want to say that the plan was intended to help people that need help. The idea of the deferred, again, coming back to a person living long enough to sell their house and then using those funds to move into some time of age restricted or what's the one where they have assisted living. These are very expensive. You're looking at $80,000, $90,000 a year in some of those. So you don't come out with a lot of money after you sell your house. We attempted to put a safeguard on this. The Board of Finance has to approve a cap for this every year. If this is too expensive for that particular year, the Board of Finance can put a limit. The same way they sit there and put limits on each department's requests, the Board of Education's request. If you'll notice, they put in for 6.2%, and the Board of Finance brought them down to 4.4 or thereabouts. That's a safeguard. So if it gets too expensive for the town, and I'll tell you one thing, I go to almost every Board of Finance meeting. Those people do not give our money away under any circumstances. The idea of a look back of 5-year or 3-year or 2-year, we don't really care what someone earned 5 years ago. We're concerned with what they're earning now. The fact that a person could have a $500,000 house, they may have purchased that 30 years ago, 40 years ago, when they had high incomes. But at this point, their money's gone. So they're living in a very expensive house with very little money to support it. We tried to hit every base we could, but I'll tell you this, I don't think anyone could cover every single possibility of something happening. I mean, there's countless things that you can do. You want to trust, you trust people. You have a $500 fine for someone that files a fraudulent form. According to Jennifer, that's a state statute. You can't make it 1,000 or 2,000. You can't put them in jail. That's what the state tells us we can do. I want to support this. It's the start. You can come back and improve on it, change it. But if you don't start a program, you're never going to have one going. Thank you.
Seeing no other comments, there are more comments. Excuse me, is the man with the hat, are you wishing to speak again? Then I'll call upon Sally Buemi at the end.
Just one other quick comment. I don't know if people realize that it could wind up under certain circumstances that the money that we are forgiving could wind up, that the taxes that the town is forgiving could wind up going to the state. Because if, let's say a person is receiving state aid such as Medicaid, and people don't realize that whenever they receive benefits from the state does not look at that as a gift. And if they have the opportunity to recover it, they will. And if this house becomes available, they will take that money out of the proceeds of the house. And so the money that we are forgiving would wind up going to the state, if not the heirs.
Mrs. White. Sally, before you, I wanted to give you the last word, Sally. Hold on.
Mary White, Summer Lane, I just wanted to ask one more question, and that is, if this is passed tonight, there was talk as to, maybe we could revisit it in a year and to maybe make some changes. So I just want to make sure, and I'm asking if the way that the senior tax freeze ordinance is written, if that indeed allows changes to be made in a year after we've seen the reality of the tax program.
I can answer that for you in that this is an ordinance, it's passed by the town meeting. The town meeting can pass further ordinances at its pleasure at any special meeting properly proposed.
Okay, and with that answer, can you tell me whether or not, if after a year, after we've seen the program in effect, if there is sentiment that the reach back and the lien should become part of the ordinance, are you saying we would have to have?
Same answer. The town can pass any ordinance that is valid under state statutes. The town is what is called a creature of the state, so it can only do things, it only has powers to give benefits or impose things that the state has allowed it to do. Most of them are in Title VII, the powers of municipality. As long as this town meeting, collectively gathered here, follows state law, it can amend its ordinances in any way it wishes.
So the answer is yes.
That would be the short answer. I believe that would be correct. Ms. Buemi.
Thank you, Mr. Lambert. Just one quick thing. Several people have made some comments about Medicaid and trying to compare some of the provisions or lack of provisions in this ordinance with some of the safeguards that Medicaid has, like I've been practicing law for 35 years almost, and certainly people do make major estate planning decisions to try to avoid Title 19, and that's why Medicaid has the 5-year look-back rule to see if people dumped assets in order to qualify for Medicaid. But Medicaid really is tens of thousands of dollars a year in benefits, if you're in a nursing home especially, and that's what people are always worried about. I really don't think people are going to do major estate planning maneuvers to save $100 or $200 a year, which is what they'll be saving in this tax freeze. So I'm not too frightened by the lack of provision in this to look back 5 years to see if assets have been dumped in order to qualify for the asset limits. The gain of a couple of $100 a year is just, I don't think, enough incentive to make those major decisions, which is what you do have in the Medicaid situation. So I think it's a little bit of apples and oranges there. Thank you.
Thank you. Now I will call the question, and since I am not certain of my ear being able to determine the ayes and the nays, may I ask Sally Buemi, our selectman? Pardon me? I'm sorry, if there's anyone else that I wanted hands up, if there's anyone who wishes to respond, please do.
I think that the promise was made that I would, so I shall. First of all, with regard to the penalty, I just want to reiterate again, it is state statute driven. It's 12-170W subsection B, which reads, any person knowingly making a false application for the purpose of claiming property tax relief under section 12-170V and this section shall be fined not more than $500. Not more than $500. Okay, and that language is in the ordinance, taken directly from the statute. There were a number of comments made about pensions versus retirement accounts. Again, keep in mind, that portion of the ordinance talks about what will be a countable asset versus what will be excluded from countable assets. A pension would still be considered income. So it's not as though what you may be getting in terms of a defined benefit for a pension is not being taken into consideration. It is income. And if it bumps you beyond the limit as provided by 12-170AA, then guess what? You don't qualify for this program. So please, the distinction, again, between income limits and asset limits, an important one to keep in mind when you're voting. There was also the question asked, and I hope I hit everybody's comments, but there was the question asked a couple of times. Mary White raised it, I think somebody else raised it. Can the assessor ask for more than just 2 years' worth of tax returns? Absolutely. If there's something in the tax returns, the 2 years' worth of tax returns that the assessor sees that he has a question about, and it goes to his determination about whether or not somebody qualifies for the program, whether or not they qualify as far as income limits, whether or not they qualify as asset limit, he can ask for additional tax returns. Absolutely. The language of the ordinance provides him with that discretion. I think that's very clear. I think it's unquestionable. I think it's indisputable, meaning if it is challenged, we are on good standing as far as the language that we have. The comment by Donna Levine, who I have great respect for, as to, looking to help the poor, help the unemployed, help the disabled. What we're talking about here is helping the seniors. There are municipal option statutes. Again, we have to have statutory authority to provide this relief. That's very clear under the law. It's a piece of advice that I am 100% correct on. I have no doubt about that. Well, people may disagree with me. I am 100% correct about that. The municipal relief that we're looking to provide here is to elderly, again, to freeze the amount of tax that they pay. The statute that is applicable is 12-170V, not 12-129N that's been mentioned. There's been a lot of discussion about one of Guilford's tax programs, which is their freeze program. That program was passed 5 years before 12-170V was passed by the legislature. 12-170V is the state law, not Jennifer Coppola's statute. It is the state law for the type of program that this town is looking to pass or is being proposed to the town meeting. Again, 100% certain about that piece of advice. I talked to the drafter of the Guilford ordinance in question. They used 12-29N because there was no 12-170V. Furthermore, I will not recommend to the town meeting that you pass any ordinance that does not comply with state law. That's what you call a bad piece of legal advice. In terms of length of residency, I just want to make a couple of comments. There was comments made about length of residency and what the length of residency should be. The statute provides a minimum. There is some flexibility. It says you must be a resident for at least 1 year. What's being proposed is 5 years. Somebody proposed 20 years. I mean, it is possible to do that, but what's being proposed is 5 years. There was another comment made about why would you not give relief, and people raised this a couple of times, why would you not give relief to people who couldn't pay last year? So the idea that people who are in arrears on their taxes, there's a provision in the ordinance that they can't participate in the program. The thing that you have to think about is freezing their taxes. They can't pay. Freezing them at the rate that they can't pay. Again, this isn't necessarily a piece of legal advice, but how is that helping them? They can't pay the rate. You're freezing them. It's not going to help them by you allowing them to qualify if they can't pay. I can't say enough about this issue about the income limits. I'm going to I know it's going to kill you because it's 9:30 at night. I'm going to read for you again from the statute. It says, to qualify for the tax relief provided, this is 12-170V, to qualify for the tax relief provided in this section, a taxpayer shall meet all the following requirements. Shall means must. It doesn't mean maybe, it means must. And the last requirement, number 4, the taxable and non-taxable income of such taxpayer, the total of which shall hereinafter be called qualifying income in the tax year of such homeowner ending immediately preceding the date of application for benefits under the program in this section, was not in excess of limits set forth in section 12-170AA as adjusted annually. And it goes on. It is a requirement for the type of program that's being proposed. That is one of the requirements. These are the income limits. It's set by statute. End of story. Questions asked about passing law and ability to make changes. That was answered by Attorney Lambert. If you want to make a change next week, you can make a change. Town meeting is a legislative body. As long as the meeting is properly noticed and the information is properly dispersed, meaning the posting of the proposed ordinance, again, you could change it in the immediate future if it's something that you're looking to do. The veterans' income level was raised. Veterans relief covered by a different statute. It's not included in the statute. Again, that's looking to set the amount of tax people pay. Okay, I'm sorry. Thank you.
There's no need to move to call it because I see no other comments and we've had the response. I will call the question, but again, because I'm not certain that I can trust my ears to figure out who the winner is, I'm going to ask, Ms. Boemi, would you count that half from the middle of the aisle on, including the 2 in the, or 1 I can't see in the upper? And Mr. Johns, would you count this half of the audience, please? I'm going to call for hands here. Pardon me? From the center. No, from the center of the center section, the right half. Do you see the well there? Okay, to the right of that, everyone including in the back. So I'm going to ask all people who are in favor of resolution number 2 to raise your right hand and keep your right hand raised until the count is done. And in the back. No, not in the back, okay. Well, that's doesn't have his hand up. Ms. Boemi. Three, including yourself? Okay. 3 and 27, and including the wing over here. And on the stage, is there any aye? Aye and aye. So we have 3, 27, and 2. Those who are against the resolution, please raise your hand. Vote then, as moderator, I declare the vote to be 32 to 30 The motion passes. I declare the meeting adjourned, there being no further business before this meeting.
The preceding program is brought to you in part through a grant from the town of North Haven. Watch town meetings or other videos on demand at nhtv.com. Like us on Facebook and subscribe to us on YouTube.